state is silent. Mr. Williams goes from April 1 all the way till June 2 without a trial. It's not the court, that is the state of Georgia. Mr. Williams, if you want to, not you, but if the court finds that, hey, there's good cause, this is what I'm finding, my April 22, 2025 court is in place within this first 60 days from the lifting of the state, I'm not conceding that, okay, because that scenario, in 60 days would end on June 23rd, 2025, without any word from the state that 60 days is going by, we want to hear. And I'm making myself available. I can put that in writing. I can do that. So I think the state is in. I just think they're out. Now, let's just say, I'm not saying it's true, but let's just say the court finds that that state is irrelevant, it's void, you get notice, so we're not doing the state. Mr. Williams still was. Then what happened was, according to the records, the last person accused in the case related to this case, the civil forfeiture case, the American forfeiture case, was stayed longer, the first judge on the case until the last person resolved that case. So that would be June 10th. That's an automatic, everyone's on notice, that's what the order says, the stay is over. 60 days starts right now. Well, 60 days starts from June 10th, which is the day, the next day, June 11th, really count. It's on the next day. So I counted this, and that would run on the 12th day of August, I think it's the 11th, but I'll say the 12th day of August of 2025. The court entered an order on June 24, 2025, so that's after Mr. Eppinger resolved his case, but it said for outside the 60 days from June 11th, and the state is silent. And under Brownsville, I would be violating the law by alerting the court. But what I do, your court asks, are you available the weeks of July 21, 2025 or July 28, 2025? That's within the 60 days. I don't know about the state at the time. So I'm thinking, the state must have alerted somebody. That's fine. And I write back, yes. I'm available both weeks. And just let us know. The state said that they need more than a day, they need a day and a half, and then it gets scheduled out. There's no mention of anywhere in any of these orders for good cause shown. There's zero mention of it. The court would have to do it on its own. This honorable court would have to say that regardless of the fact that the state did not do its job on getting the court aware of the 60-day limit, and instead of putting it on complainant, which you can't do, then somehow the court says, the court's taking the position that it was pretty cause. It's never written anywhere. That would be the first time anybody would say this is pretty cause. This is not on the state, and I'm not blaming prosecutors. I'm confident the prosecutor has reason for this. The prosecutor has to either seek a continuance or try the case within 60 days. That did not happen. Your Honor. I just gave all three scenarios that I can come up with. There are no dates here. By failing to open the state, let me just address this. I did respond when I saw the date on June 24, 2025 being today, on the 15th. I mean, it's just my nature. I did state says that thank you so much somehow is being agreeing or waiving my 60 days on behalf of Mr. Williams. I don't have to object. And I'll give you that date as well.
Steel is not using the mic. Steel is not using the mic, that's why you can't hear.
The forfeiture statute requires the state to timely initiate a forfeiture action to seize property. That's right in the bill. The state failed to schedule a trial date or request a continuance within the second 60-day period following the filing of the complaint. That's also in the bill. That happened exact case number 1 second. Okay. Now it's Goodwin, G-O-D-W-I-N versus State, 321 Georgia Appeal, 548, 739, 728, 2003. Would you like a copy? And in the footnote 7, the court wrote, there is no evidence that Goodwin consented to a hearing date outside of the 60-day deadline. Rejected, and then it cites the Griffin, G-R-I-F-F-I-N, 250 Georgia Appeal at 94, 95, 81. Rejecting the state's argument that claims waive their right to a speedy resolution of their property rights by failing to object when the hearing was scheduled on a date outside of the mandatory 60-day period. You know, I would be doing this to this service. Now, I did see it. How much money came in by I'm going about the rule? And I thought, hey, I told him to do that. I told him. So I think you're out of time for it. Follow up. So, I don't understand your question on all that. Nothing to do with the facts of the case.
Thank you, Mr. Stewart.
Nothing to add, Your Honor. We'll see our response.
Thank you. I do believe that it is correct that notification of a legal conflict does not equate to asking for a continuance. You know, I think counsel, we all feel like that people worked hard in good faith to try to find a hearing date, and we ended up with the hearing date of today. But the procedural rules and requirements of these forfeiture statutes are mandatory. The statutes are strictly construed against the state. There was no request at any time for a good cause finding to move the hearing outside of the windows that are statutorily required. I don't believe that acknowledging a hearing date operates as a waiver. The burden remains on the state the entirety of the time. And like I say, there was never any kind of request to the court to find a good cause based upon the hearing date being set for when it was, and I think that the court has no option under the case law and under the statutes but to grant this dismissal. So the dismissal is granted.
Oh, they got it.
And I don't know whether the state has any intention of appealing or not. That's not a determination you'll have to make right now. But I would imagine if there is an appeal that the piece of property will be stayed until after that is sorted out. But at this point, that's the court's ruling.
Thank you.
Thank you.
That was quick. That was quick and sweet. We rule on Steve's behalf, y'all. We got it. Huh? All right, we're gonna end. Okay, y'all, I'm gonna end this. Still one. With his wife. All right, y'all, this is the end. All right, we're gonna go talk to Steele now. Yes, I have your charger.